have a timer running, because I do realize we are already late. Good morning once again. It's a great pleasure for me to be here and to talk about the protection of databases, because there have been a few recent developments that I think you should all know about. What I wanted to do this morning when talking about databases and the protection is that I would like to give us a few examples and definitions and then look at the international legal framework of the protection of databases before turning to the situation in Europe. And particularly when it comes to the protection by a sui generis database right, there have been these recent developments over the last maybe 3-4 years that have had quite an effect on the scope of application of that right. And so we'll look at that at the very end. I should say that I really try to focus very much on the situation in the EU because that's of most relevance to you. So there's no comparative analysis of how things are done, for example, in other parts of the world, in the US. So that's outside the scope of the presentation this morning. Now, a definition that is often given is that a database is an organized set of information and information retrieval tools. I think this sums it up quite nicely, and the EU Database Directive has a legal definition of database. It says a collection of independent works, data, or other materials arranged in a systematic or methododic way and individually accessible by electronic or other means. And so, as you can see, this definition is relatively broad, and I'm listing some of the examples: dictionaries, encyclopedias. So it can be online databases, can be physical databases. All of these at some point were judged to be databases. Now, if we look at the international legal framework, we'll have a quick look at what the Berne Convention says, the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights, and the WIPO Copyright Treaty, WCT. And I'll also say a few words of protection for non-original databases that was discussed at the international level at some point. Now, given that we're already late, maybe I'll try to cut this short. This is Article 2 of the Berne Convention, and in paragraph 5 of that article, we have a specific mention of collections of literary or artistic works such as encyclopedias and anthologies, which by reason of the selection and arrangement of their contents constitute intellectual creations. Those shall be protected as such without prejudice to the copyright in each of the works forming part of such collections. So this really is the situation in which all the different elements of the content of the database in themselves already enjoy copyright protection, but then the database as a whole will enjoy copyright protection because of the selection and the arrangement. So this is how the originality expresses itself in the selection and in the arrangement. And of course, the copyright protection in the collection is independent of the copyright protection in the individual pieces of content. Now, what about databases that compile content that is not individually copyright protected? The Berne Convention doesn't say explicitly anything about that. But of course, Article 2.1 of the Berne Convention states that literary and artistic works shall include every production in the literary, scientific, and artistic domain, whatever may be the form or mode of expression. So there is quite a widely held view that this would also cover copyright protection for databases, even if the content of the databases are not individually protected by copyright. Even if we don't believe that, we now have the TRIPS agreement. Well, now, it was, of course, signed in 1994, and this wording of Article 10.2 of the TRIPS agreement follows very much the wording that we've seen already, but it makes it clear that it includes also non-copyright protected, the compilation of non-copyright protected data. So it says specifically compilations of data or other material shall be protected by copyright. Again, the originality expresses itself in the selection and the arrangement of the data, and it covers both physical and digital databases. So this is the little part where it says whether in machine readable or other form. There is a clarification as well that the copyright in the compilation does not accord copyright to the compiled material if it's not otherwise copyright protected. And of course, the copyright protection in the collection is independent of the copyright protection in the collected works. The WIPO Copyright Treaty, which was adopted in 1996, and basically tried to make the international copyright framework fit for the digital environment, contains basically the same provisions. So again, we have a confirmation that copyright protects compilations of data. If, again, they constitute intellectual creations because of the selection or the arrangement of the content. Now, what about those databases that are not intellectual creations, that don't have originality because of the selection or the arrangement? And here there were discussions going on at the international level from 1991 onwards. And actually there was even a text that was tabled for a potential treaty on the matter. But the diplomatic conference in 1996, which later adopted the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty, ran out of time, so they didn't discuss that proposal. Our member states at WIPO, they continued to talk about it for a little bit longer until 2005, but there was no appetite to really agree on an international instrument. So what does that mean? It means that copyright protection for original databases, so that's databases that are intellectual creations because of the selection of the data or because of the arrangement of the data. This is pretty firmly anchored in the international copyright system, and all of our member states and all of the WTO member, World Trade Organization members, must provide copyright protection for these type of original databases. And given that there's no international agreement on the protection of non-original databases, it means that national states are free to afford such protection, but it can only be in addition. It cannot replace the copyright protection for original databases. Now, if we look at the situation in the EU, we have Directive 96/9/EC, which is the database directive, and that one establishes a dual regime. It establishes copyright protection, again, for original databases, and a specific sui generis right for non-original databases. And we'll have a quick look at both of them. I will skip a few slides. These are the articles on copyright protection. There is nothing particularly astonishing in there. So it stipulates that these types of original databases are protected. It also has provisions on who the author of the database is. It has provisions on what particular acts are restricted when it comes to original databases, and it lists some exceptions to the exclusive right of the author of original databases. Now, more interesting, I think, for our purposes, really is the sui generis right, and that one is anchored in Article 8 of the Database Directive, which says that member states, EU member states, shall provide for a right for the maker of a database which shows that there has been qualitatively and or quantitatively a substantial investment in either the obtaining, verification, or presentation of the contents to prevent extradition and/or reutilization of the whole or of a substantial part, evaluated quantitatively or qualitatively, of the contents of that database. Now let's try to unpack that a bit. The right that is accorded to the maker of the database. And it protects any substantial investment that the maker of the database has made, either in obtaining, verifying, or presenting the content. Now, substantial investment, what does that mean? We don't really have any definition in the directive, so it really is a case-by-case analysis that needs to be done here. There is a little bit of an indication in the recital, which says that making a database requires the investment of considerable human, technical, and financial resources, so we're not only looking at money spent. And it may consist in the deployment of financial resources and/or the expending of time, effort, and energy. We got a little bit of guidance by the Court of Justice in 4 judgments in 2007. Basically, the Court of Justice of the European Union interpreted Article 8 of the Database Directive in a slightly reductive way, in a narrow way, because it says that investments in the obtaining of the contents, this must be understood really as the resources used to seek out existing independent materials and collect them in a database, and not to cover the resources used for the creation of the materials which will later be making up the content of the database. So what happened was that the court restricted the scope of application of Article 8 compared to an interpretation that is strictly based on the wording. Now, that right, what does it give the maker of the database? Basically, it gives the maker of the database an exclusive right to prevent extraction and/or reutilization of the whole or a substantial part of the contents of the database. And extraction means the permanent or temporary transfer of all or a substantial part of the contents of the database to another medium. So basically something along the lines of copying, arguably a bit wider, because it can also be the transfer without leaving the original copy intact. And reutilization is the making available to the public of these substantial parts of the contents of the database. And these are the acts that are prohibited. There are certain permitted, specific exceptions that apply to what the directive calls lawful users, which are users to which the right holder has chosen to make available a copy of the database. And that's basically extraction for private purposes of the contents of a non-electronic database, extraction for the purposes of illustrating for teaching or scientific research, and extraction and/or reutilization for the purposes of public security or an administrative or judicial procedure. The term of protection is 15 years from the date of completion of the database, or the date. I think I didn't quite note this down correctly in the first bullet point. So it's either from the date of completion of the database or the date of making the database publicly available, if that happens within the first 15 years. But every time the maker of the database substantially makes another substantial investment in the database, updates it, amends it, shortens it, then that again sets in motion 15 years of protection for this amended database. So it can be perpetual protection if the investments continue to be made by the database maker. Now, why do we have this right? It's a question that many scholars have a bit of a hard time answering. But of course, the rationale for this right, at least as it is laid out in the recital of the database directive is that there was a feeling that we should protect database makers against the misappropriation of the results of financial and professional investments, even if they don't enjoy copyright protection. So even if there is no intellectual creation because of the selection or the arrangement of the contents. And it was pretty clear at the time. It was also made to bolster the competitive position of European database producers, because it was the beginning of the information society, and it was really felt that in order for the EU to be at the forefront of the development of the information society, we should make sure that database producers are appropriately protected. Now, there's a lot of criticism, has been already over the last 25 years, when it comes to the sui generis database right. And mainly what the critics say is that there is a high risk of overprotection. First of all, this criterion of substantial investment is not really objectifiable. And what do I mean by that? There's this quote from two scholars that I wanted to share with you, who point out that the threshold of protection is untransparent to a potential user, because as a user of the database, I don't know whether the database maker has made any investments in the database and how high these investments were. It's hardly verifiable, it's difficult to prove, and it does not lead to the same outcomes when presented with the same data set. So two databases which have exactly the same content may be protected if the maker has made substantial investments, or may not be protected. So this is the criterion of substantial investment. There is more criticism saying that the exceptions that we have are too few and too little robust, plus they're only optional, so EU member states don't need to implement them. They can also be overridden by contractual use terms, and there is a bit of an unclear relationship between the sui generis database right and competition law, because the database directive specifically says that competition law remains applicable. And so there may be situations in which protection under the database directive would not be given, but through the back door of competition law, perhaps it can be enforced. So there is a feeling that it may not be leading to just results in all cases. And even the European Commission, they evaluated the database directive twice, 2005 and 2018, and they found no evidence that the sui generis right had any economic impact, but still they recommended maintaining the status quo. Now, this was the situation until 2019. Since 2019, we had a few developments, which I will share with you, and I think if we're lucky, I'll even be on time, that have changed the scope of application of the sui generis database right. Now let's look at them in turn. So first of all, the adoption of the directive on copyright in the digital single market, because here there are obligations for EU member states to create exceptions and limitations that are apt for the digital and cross-border environment, and they have implications also for the sui generis database right. Namely, there is a text and data mining exception for the purposes of scientific research. So this is the idea that we would allow for the large-scale harvesting of information in an automated way, which will make it possible to see connections, to gain new knowledge and discover new trends. So it's seen as something positive if it happens for the purposes of scientific research. And so research organizations or cultural heritage institutions can extract and reutilize data from databases under Article 3. Article 4, another text and data mining exception, this time general, meaning that it doesn't have to be only for purposes of scientific research. It can be for any purpose. However, there is an option for the right holder to opt out. So the right holder can say, don't take my data. How exactly the right holder should do that is still a bit of a discussion. Article 5 another exception for use in digital and cross-border teaching activities, in Article 6, an exception for the preservation of protected subject matter by cultural heritage institutions. So the Digital Single Market Directive created these 4 additional exceptions to the sui generis database right, and that of course curtailed the scope of application. Now we come to the case that Sane already mentioned, CV Online versus Mellons. So this is CV Online's page. It was a reference preliminary ruling, as you all know, and CV Online, the page that you saw before, fully developed and regularly updated its database of job advertisements. And on each page, there were also invisible HTML meta tags for job title, name of the undertaking, place of employment, and date of publication of the job advertisement. Now, this is the meta search that Mellons operates. So here, users can select various criteria, including the type of job and the place of employment, and then results come from several of job advertisement searches. And the results, they contain deep links to the source website. So it means if you have a link, you can click on it and you get to CV Online's site. And also the results display the information that is contained in the meta tags. So the question, of course, was, is that an infringement of the sui generis database right or not? And CV Online claimed, yes, it violates the database right, because it says that scrapping the meta tags is an extraction and a reutilization of a substantial part of the content of the database on the website. On the other hand, Mellons says that they don't really do real-time search, but only periodic scraping of the metadata, and that the meta tags are part of the website and not the underlying job advert database. Now, the Court of Justice of the European Union is pretty quick at establishing that by copying and indexing the content of CV Online's database, there is an extraction. And by giving users access on their own website to the job ads contained on the CV Online database, there's also reutilization of the content. So we have these restricted acts that are happening. However, then the court comes up with a new criterion that didn't exist before, saying that not every restricted act is actually an infringement. For there to be an infringement, we need to be more. We need to have more. We need to have an effect that deprives the person of the income intended to enable him or her to redeem the cost of that investment. So it's not only whether there's a restricted act, but whether the restricted act is likely to deprive the database maker from redemption of the cost of that investment. So this is a new criterion. It bases on recital 42, but it's the first time in 25 years that it was applied. And the court even goes a little further, because it says that it is necessary to strike a fair balance between, on the one hand, the legitimate interest of the maker of the database in being able to redeem the substantial investment, and on the other hand, the interest of users and competitors of those makers in having access to the information contained in those databases, and the possibility of creating innovative products based on that information. So this is also something that happened for the first time, that we look not only at the right holder, but actually we incorporate some broader public interest considerations. Now, how do we get to a fair balance? Well, we need to balance the risk that the database maker has in not redeeming the substantial investments they made, and need to balance it with potential positive outcomes for society as a whole. Now, of course, the Court of Justice of the European Union did not decide the case, but they did say that there is added value to have these aggregator sites. They said that these aggregator sites actually allow for information on the internet to be better structured and to be searched more efficiently. And by doing that, it also contributes to the smooth functioning of competition and to transparency of offers and prices. So basically they're saying aggregators, they're a good thing. But now, go back to Riga and you apply the criteria. And I was not entirely sure what the outcome was, because I was following your description. But what was finally decided when these criteria were applied?
No infringement. No infringement.
Ah, no infringement.
Yeah.
That's very interesting, because there was also another case in Sweden in 2022 about parking apps. I don't know whether you know these apps. If you need, yeah, okay. So I don't need to go into detail. And there are also aggregator apps that basically combine the results that tell you, if you use this parking app, it's a little bit cheaper than the other one. These type of things. And the court in Sweden actually found infringement. But of course, the circumstances were different. I'm just mentioning this to say that the criteria that the Court of Justice establishes seem to be wide enough to come to equitable solutions depending on the circumstances. Now, the last element that, so just to recap, so of course, introducing these new criteria further curtails the scope of application of the sui generis database right. Because we now have to see, is the restricted act a risk to recoup the substantial investment, yes or no? And in this assessment, do we need to accommodate public interest considerations? Now, the third element that further curtails the scope of application of the sui generis right is the EU data strategy. There were 3 instruments that were adopted since 2019. The Open Data Directive, which basically tries to make the public sector and publicly funded data reusable. We have the Data Governance Act in 2022, which increases trust in voluntary data sharing mechanisms. And we have the Data Act from last year, which clarifies who can do what, who can use what data and under which conditions. I'm not going into detail of all these instruments because I don't understand them, but this is basically the trimmed down summary. And each of these instruments, again, I won't go into detail, but what is important to note is that in each of these instruments, there was a certain conflict between what the instrument tried to achieve and the existence of the sui generis database right. And in each of these instances, the scope of application of the sui generis database right is curtailed. So, for example, it says that the database right shall not be exercised by public sector bodies in order to prevent the reuse of documents or to restrict reuse beyond the limits set by the directive. Similar wording in the Data Governance Act, and the Data Act, Article 43, says that the sui generis database right shall not apply when data is obtained from or generated by a connected product or related service. So connected product is basically every product that is connected to the internet. So a big part of the previous scope of application of the sui generis database right. So, what conclusions can we draw from all of this? I think one conclusion that we can draw is that realities have changed since 1996. Back then, as I said, giving makers of non-original databases the sui generis right was perceived as also fostering Europe's competitiveness vis-à-vis other third countries that were more favorable to database makers. And making of databases, as I said, was perceived as being the backbone of the information society. And today it's a little bit different, because another quote: the current data governance landscape is much more complex than the one that provided the backdrop for the ill-conceived database right that considered database producers to be the backbone of the information society. This basic assumption does not hold anymore in an environment in which nearly every economic transaction or productive process creates data. So it's really a very different situation. It reminds me a little bit of the current trend that we can perceive when it comes to the liability of intermediaries when it comes to infringement. So the hosting exception, the caching exception, all the safe harbor that we had in the late 90s. Ooh, I guess I'm over time now. That we had in the late 90s, which slowly by slowly we realize that they actually don't need this protection anymore, these type of entities, and there's a shift again to sort of roll that back. We have these very, very largely reduced scope of the application of the sui generis database right. And so one can, of course, ask, and of course it's not up to WIPO to ask these questions, so I put the question of one of the scholars on the screen. It seems time to ask how much scope of application of the sui generis database right remains. And more importantly, is whatever scope remains really worth incurring the significant legal uncertainties that are caused by intransparent criteria for protection? I think it's a question that I actually wanted to put to you, even though I think we don't really have time for discussion anymore, but maybe you have an answer to that question. With that, I would like to thank you for your attention.